All right, good afternoon, everyone. Thanks for joining us for today's webinar, which will be focusing on understanding the ADA and interactive process. So we appreciate you spending the time with us for this afternoon. For those of you who have joined us before for our other webinars, a few housekeeping items that will sound familiar. Today's webinar is being recorded, and we'll make sure to send that recording out at the conclusion. Attendees are encouraged to submit any questions that you might have throughout the questions panel in the user interface. We do have a few questions that were submitted in advance of today's webinar, and we'll be answering those towards the end of our discussion. And then lastly, contact information for both myself and Mary Ellen Allen, who we'll hear from in a couple minutes, is going to be shared on the next slide. So please make sure to use that information should you need it. So with that, my name is Matt Rossler. I'm the Director of Business Development here with PROXUS, and I'm lucky enough to be joined again by Mary Ellen Allen of Lamb McErlane, one of PROXUS's many law firm clients. So some of you may remember Mary Ellen if you joined us a few weeks back for our webinar on navigating the new normal, reopening offices during COVID-19. Mary Ellen is the co-chair of the Employment Law Department and a member of the Litigation Department at Lamb McErlane. She concentrates her practice in employment law and commercial litigation. Mary Ellen, it's good to have you again with us.
Thanks, Matt. It's great to be here.
So in a lot of ways, the webinar that we're focusing on today is an extension of that reopening discussion we had a few weeks ago. You know, at the time, we spoke a lot about employees who may have concerns with wearing a mask in the workplace for medical reasons, which may have implications for the Americans with Disabilities Act and certainly the interactive process. So for that reason, we thought it was important to spend some time on that topic today. Few things that we'll be covering today is going through, exactly what is the interactive process and why do we need it? Why do we have it? We'll talk a little bit about who's required to follow the interactive process. Certainly, we're going to touch on how do employees know when they need to engage in the process. What should the process look like and what forms or documentation should be used? And then are there any circumstances where an accommodation can be denied? And we'll learn a little bit about, how accommodations play into the interactive process in a second here. So with that, we'll jump right in and, start to talk about exactly what the interactive process is and why we need it. So Mary Ellen, I know many of us on the call will know, what the interactive process really comes from, which is the Federal Americans with Disabilities Act that was passed originally back in 1990 and amended since then. But if we go to the next slide here, for those who aren't aware or who need a refresher course, give our listeners an idea of what the ADA is and why we have it among our, copious amount of employment laws and that alphabet soup that we have.
Absolutely, Matt. Title I of the Americans with Disabilities Act directly affects employers, and it prohibits discrimination against individuals who are qualified for a position, and it prohibits against discriminating in the application process, hiring, whether it's promotion, advancement, compensation, job training, and even considerations for termination. So with regard to the ADA, if someone has a disability, then they are covered by the Americans with Disabilities Act. And ADA has a very broad definition of disability. It's a physical or mental impairment that substantially limits a major life activity of an individual or a record of that kind of impairment. And major life activities include, but are certainly not limited to, seeing, hearing, sitting, standing, walking, lifting, sleeping, breathing, thinking, many more. Several years ago, the ADA was amended and the definition of disability became rather broad. So it does cover a whole host of either physical or mental impairments.
Got it. And I know that's one of the things that, in our work with employers on these types of things, the definition of disability always comes up, right? So it's not always that outward physical, something you can observe, right? It could be, which is, I think, a really important part with all of this. It's not always an easily observable disability or impairment.
That's exactly right. Sometimes it is. Someone comes in a wheelchair. It's very obvious then that they have a physical disability, but there are many times where the disability is not open or obvious. to the employer. And we're going to talk about this later, but there is a line as to, there are certain restrictions on what an employer can ask of an employee with regard to their medical condition. And we'll get into that later.
Yep. And for some employment laws, like I said, the alphabet soup earlier, employee account is a tipping point for having to comply, right? So one of them most well known probably that a lot of us on the call will recognize is the FMLA, so Family Medical Leave Act, and
Right.
that 50 employee mark. What
Yes.
about with the ADA? Is there a quote unquote magic number where private employers need to be concerned with compliance?
Yes, the number is 15. But a lot of states have analogous state laws that have the same requirements, and the number of employees that's necessary to be covered by the state laws is usually less. For example, in Pennsylvania, it's 4. Philadelphia has its own ordinance, and for that, you only need 1 employee. And,
Yep.
before we move on, I neglected, I wanted to talk a little bit about COVID. I know a lot of people have questions as far as, is COVID-19 considered a disability under the Americans with Disabilities Act? COVID-19 standing alone, as long as the individual that has COVID doesn't have a severe case of COVID-19, if it's just the mild temporary symptoms, then standing alone is probably not a disability. But if it's contracted because the person has an underlying medical condition that made them high risk, and therefore they contracted COVID, or they have a more severe case of COVID, then in those cases it can fall under the Americans with Disabilities Act.
Got it. Okay. So I think the 3 biggest takeaways from this slide here are, disability is not always easily identifiable, right?
Right.
We know that the ADA and the implications of the ADA really do affect application through to termination of an employee, right? It's the entire employee life cycle, and employees may be a little bit too narrow, right? It's also applicants. So those who aren't employed by you. And then, as you just mentioned, the fact that states and localities have their own laws that, are more beneficial to employees, where that number may fall below the 15 employee count.
That's exactly right.
So if we move to the next slide here, without giving too much away, since we're going to be covering aspects of this in more detail, what exactly is the interactive process? I mean, it's certainly one of the phrases we learn in our HR studies, and, whether those of us on the call have gone to school specifically for HR, or, like many of us, you simply kind of fell into it and you wear that hat along with all the others that you have. What does the interactive process mean?
Okay, so the interactive process, it's a discussion about an applicant or an employee's disability. Okay, the applicant or employee and the employer, and sometimes a healthcare provider for the employee, each share information about the nature of the employee's disability and the limitations that may affect his or her ability to perform the essential job duties. And they do so in order to find a reasonable accommodation that will allow the employee to complete the essential functions of the position. That discussion, it's the foundation of compliance with the Americans with Disabilities Act. Sometimes it's not necessary because it's open and obvious, like the example I used earlier. If someone has a wheelchair, they're obviously going to need a ramp or some other way to access all areas of the building. That's more of an obvious one, and you don't engage in the interactive process. But for some, it's not open, it's not obvious. And it's a two-way communication between the employee, the employer, and bringing in the employee's healthcare provider when necessary.
Got it. And who would you say this process and the discussions that you just mentioned are designed to protect? Is it only on the books to protect applicants and employees, or is there some level of protection that flows both ways and covers the employer as well? It
certainly flows both ways, because the interactive process imposes a duty on both the employer and the employee. So if the employer is reaching out, communicating with the employee, trying to find some reasonable accommodation, and the employee just is not receptive, does not respond, then the employer has fulfilled its duties under the Americans with Disabilities Act, even if a reasonable accommodation has not been met, because the employee has to do their part as well. It's a two-way street, and the burden is on both parties.
Okay. All right. Good. So I guess moving on from there, then, we're going to look next at when to engage in the interactive process. So now that we know why we have the interactive process, who's covered under the ADA, and the broad definition of a disability, let's take a look at when to engage in this process. And as we just said, with a lot of things in life, communication is certainly key. But as all of us know on the line today and understand, communication is not always easy, nor are those intentions and information always clear. So as we can see on the next slide here, the conversation can really be initiated by either the employee or the employer. So let's take a step back and discuss how that begins, because I know in some cases, but not all, an employee will simply walk in, notify their employer of the need for accommodation. And, if you're lucky, they may even put it in writing or have some supporting documentation from a doctor in hand. But more often than not, that's kind of the exception rather than the norm, right? So as you're working with clients, Mary Ellen, what are some of the ways that you've seen employees make a request for an accommodation that would necessitate engaging in the interactive process?
Sure. I've seen a direct request. Somebody needs a different chair. They have a back condition. Somebody needs a leave of absence due to cancer treatments or some other type of medical treatment. But I've seen non-direct requests as well. Employees, they can use plain English. They don't have to mention the ADA or use the phrase reasonable accommodation when requesting an accommodation. So anytime an employee indicates that he or she is having a problem and the problem is related to a medical condition, the employer should consider whether the employee is making a request for an accommodation under the ADA. For example, an employee tells her supervisor, I'm having trouble getting to work at my scheduled start time because of medical treatments I'm undergoing. That's a request for a reasonable accommodation. An employee tells a supervisor, I need 6 weeks off to get treatment for a back problem. Again, that's a request for a reasonable accommodation. So, anytime I'm having trouble doing my job and it's related to a medical condition, the employer should consider, is this a request for a reasonable accommodation? If it's just my chair is uncomfortable for me, well, that's not related to a medical condition. Just seems like they just need, a more comfortable chair, and that wouldn't trigger the interactive process under the ADA. For COVID purposes, I've seen requests, they need an alternative form of testing for some reason, or they're not able to wear a mask because of a medical condition, or cannot come to work because they have an underlying medical condition, puts them in a high risk category for contracting COVID. So those are all requests for reasonable accommodation, and the interactive process is triggered.
Got it. And, in some cases, as you mentioned there, as we can see on the next slide, when the employee doesn't come directly out and ask for an accommodation or say they've got a disability, but maybe it's something that the employer, the supervisor, the manager is noticing. So whether it's a downturn in productivity or just a switch in the way that employee is acting. Are there situations where an employee, may not come out directly and ask for that accommodation, but things that the employer is noticing that should lead to a conversation about the potential need for an accommodation?
Sure. I think you gave good examples, Matt. A downturn in productivity or a performance issue during that conversation, an employer may ask, is there anything else that's affecting your productivity that we should be aware of? Is there something affecting your performance that we're not aware of? But I would tread carefully there. I wouldn't come right out and say, do you have this medical condition, or do you have an underlying medical condition? I tend to tread lightly there and ask more broad-based questions of, is there something else going on that we should be aware of that we can help with, and see if the employee shares that way.
Yep, absolutely. And anytime, no, go ahead.
No, I was just going to say, or if the employee comes and says, I just wanted to let you know that unfortunately I have cancer, and I just wanted to let you know as my supervisor or as HR, that would be a time for the employer to ask, okay, is there anything that we can do to help so that you can perform your job? Or do you need a leave of absence, or is there anything that you need that would help you perform the essential functions of your job? That would be a good time to ask.
Yep. No, and listen, I mean, as an HR consultant, I'm hyper aware of the need for training around these types of things, because as you just said, it's especially when there's a performance issue that may lead to disciplinary issues or termination on the extreme end. When you layer in the potential for an ADA claim or anything of the sort, I mean, you have to be very, very careful about how you go about having that conversation. And we'll talk in a moment about what that process should look like. And, a big part of that is who is the right individual to have that conversation on behalf of the employer, right? Mm-hmm. We've said the employer, but when it comes down to it, there's, managers, supervisors, executives. So there's multiple people that fall underneath that title of employer. Who's the right one to have that conversation? But I think the critical point to make here is that, it truly is the responsibility of both the employee and the employer, as you said.
Right.
Employers can't and shouldn't simply turn their back and not engage in the discussion based on the fact that employee was not the one to initially initiate it.
Right. Yeah. Exactly.
So if we look now at kind of putting it all together, right, now we know not only what the interactive process is and why it exists, who it protects, but also importantly, what triggers that process. So let's turn our attention to the actual mechanics, mm-hmm. And what that process should be. So we've got a couple bullet points here. I mean, let's assume, Mary Ellen, that an employer, and I use that term to mean, anybody, right? Again, supervisor, manager, executive, is now aware of an employee's disability and the need for an accommodation. What's mm-hmm. the roadmap for engaging successfully in the interactive process? Okay. And let's start that answer, if you can, like we said, with who within the employer should be leading that process.
Right. HR should be leading that process, assuming that there is an HR manager, and it's always best to have someone trained in human resources, either on site or, someone like PROXUS that's available. So that's the best person, I think, to be leading that conversation. If there is no HR manager, then someone higher up in the company, whether it be a manager, it can be the employee's supervisor, but I tend to err on the side of having just one central person who handles all of those requests rather than having each individual supervisor handle those requests. The supervisor may need to be involved in the conversation to the extent seeing how a reasonable accommodation may work for the employee doing their job. But as far as who, it's best to have the HR manager handle those. So, in terms of the process, the first thing is to gather initial information from the employee. The employee who requested the accommodation is often the best source of information about the disability and the possible accommodations. If the employee cannot provide the necessary information, then medical documentation can be useful. The ADA does not require employers to request medical information after receiving a request for accommodation. However, in some situations, employers, they feel compelled to request the medical information because sometimes the disability and the need for the accommodation, as we discussed, are not known or obvious. And employers shouldn't be making any type of medical determination. They should rely on healthcare providers for that. So the important thing for employers to remember is not to ask for too much information from the treating physician. When the employee requests an accommodation and the disability and the need for the accommodation are not obvious, then he can request medical documentation to help determine whether the employee has a disability and needs the requested accommodation, and information to help process that accommodation request. So, but if the employer needs to consult with the employee's healthcare provider, the employer must obtain a written medical release or written permission from the employee. The employee's healthcare provider cannot disclose any information or answer any questions about the employee's disability without that employee's permission. So, find out the limitation and the problem, get the information from the employee when possible, and then remember the ADA rules in terms of medical inquiries. So the next step would be to discuss and implement reasonable accommodations. This discussion it's a back and forth discussion. Again, the employee is a good place to start. The employee knows their limitations better than anyone else. So the employer should invite the employee to suggest accommodations. If more ideas are needed, the employer can ask the employee's medical provider for effective accommodations. The treating physician may be a good resource to either offer suggestions for an accommodation or at least may be able to help analyze whether suggestions will overcome the employee's limitations so that the employee can do their job. So then you have to choose the accommodation. If you can give the employee the preferred accommodation, then that's great. But the employer doesn't have an obligation to give the employee his or her preferred accommodation if there's another alternative that would work and perhaps is more cost effective for the employee. So it truly is a back and forth. It truly is a negotiation. You want, of course, the employee to have an accommodation that will allow him or her to do their job. But again, the employer's preferences and needs are taken into account as well. And whether or not an accommodation is cost effective certainly is taken into account. Then, consider a trial period. An important but often forgotten part of the interactive process is monitoring accommodations after they are in place. In some cases, the accommodation stops being effective for various reasons, such as maybe the employee's limitations change, workplace equipment changes, the job changes, the workplace itself changes, or the accommodation becomes an undue hardship for the employer. So because changes can occur, employers may need to periodically check on the ongoing effectiveness of accommodations. If equipment is involved in the accommodation, someone may need to be assigned to perform maintenance or upgrades as needed. The most important way to monitor accommodations is to encourage that ongoing communication, that two-way street. Employees who are receiving accommodations need to understand that they should let their employers know if there are changes or problems with the accommodation and who specifically that employee can contact to discuss that or to say, we need to make a change or something's not working here. And if you're unsure how it's going to work, again, consider a trial period. Hey, let's try this out for 90 days and put it in writing, and everybody mark their calendar to reassess in 90 days whether or not this is an effective accommodation. Go ahead.
I was just going to say, if we park on the documentation for a minute here, and that's our next slide is the gathering information and requesting documentation. The one bullet point that I actually don't have up here on the screen, and you had mentioned it earlier, kind of as an aside, is it's the essential job responsibilities for that position, right? And that always flows back to a solid and well-written job description. And that I think is another good takeaway from the discussion today is make sure you have, good solid job descriptions with ADA specific sections, right? So how often is this person required to sit, to stand, to kneel, to lift over certain amounts of pounds? Are you using repetitive motion? So all of those sorts of, details about the job are going to be important as you engage in this process. So the employee and potentially the employee's physician, know what goes into the mechanics of that particular job. And as you said before, Mary Ellen, it's keeping those current, right? So just as you're going to do maybe a trial period, or you're periodically checking up on making sure that accommodation still makes sense, always go back and kind of do a self-audit on your jobs and the job descriptions to make sure that the same, level of physical requirement still exists as it did 6 months ago, a year ago, 5 years ago when that job description was first written.
That's a great point, Matt. Job descriptions, it is essential to have that ADA section of a job description that sets forth the physical, both mental and physical requirements of a job, sitting for 8 hours or, lifting up to 5 or 10 pounds or something heavier than that. So this way, when you're asking the employee's healthcare provider for, can they do the essential functions of their job, you already have a list of, hey, this is what's required. What are they able to do? What are they not able to do? And, when an employer does not have to put aside the essential functions of a position in order to offer a reasonable accommodation. The employee has to do the essential functions, but there are marginal functions of a job. And so maybe those can be switched around, reassigned in order to accommodate the employee. So an employer has to focus on, okay, what are the essential parts of this position versus what are the marginal parts? One example that comes to mind is, a janitor who's cleaning, if he has bad knees and can't climb the steps, so therefore he can't sweep the steps. Well, maybe there's someone else that he works with that can do the sweeping of the steps, and that janitor can go ahead and do another marginal function, just reassign things. But of course, he's still able to do the essential functions of his position, cleaning the entire floor or taking an elevator up to the second floor. He just can't do the steps. So that would be an example of a difference between the essential functions and marginal functions of a position.
Got it. And I keep coming back to the FMLA here because, I think it's a pretty well-defined process for FMLA, right? We've got the forms and documentation that are sent out to the employee, to the physician, and that's kind of the example I'm going to ask you to talk a little bit about here, Mary Ellen, with forms for the interactive process, right? So we know that, as you said, with written approval and kind of acknowledgement,
yeah.
It may be okay for the employer to speak with the physician, but a lot of times what I've done as well is have a standard form letter that asks of the physician certain questions that help to achieve what we're trying to get at here with this conversation. But that actually goes to the employee, and then that employee is the go-between between the employer and the physician. So, for things like that, does it make sense to have a form letter and a form questions, or is each situation so unique that you can't really do that?
Well, I think you can start with a form. So, like you said, the FMLA, this is easy because the government provides standard documents for physicians to complete. But the Americans with Disabilities Act does not require employers to use standardized forms when gathering medical information from employees. So I think it's good to start with sort of standardized questions and then to adjust the form as needed, because the ADA is very case by case. It's very fact specific. Everybody's disability will be different. The job is different for everyone. So it's just very fact specific and individualized. So I like to start with a form of, standard questions of, could you review this job description? And is the employee able, if it's going to the healthcare provider I'm talking about, is the employee able to perform the essential functions of this position with or without a reasonable accommodation? If yes, then continue to the next question, which is, does the employee have a physical or mental impairment? If yes, what limitations are interfering with the job performance? How do they affect the employee's ability to perform the job functions? What adjustments to the work environment or position responsibilities would enable the employee to perform the job functions? Questions like that are helpful. So you're not asking for a diagnosis. There's no need to ask for a diagnosis. The medical provider can provide the information that the employer needs without asking for a diagnosis. And an employer should never be requesting medical records. It's just not necessary, and that rarely or ever would be considered acceptable under the ADA. So there should be no need to request medical records for an employee. Just having the healthcare provider fill out the questionnaire should give enough information.
That makes a lot of sense. And one of the last points I'll make here before we kind of move on to what is a reasonable accommodation, related to that documentation, right? So just like we talked about, having good job descriptions is important. And many of you on the call are very likely going to know this, but then there's going to be others who, as soon as you can get back into your offices, are probably going to run to the filing cabinets. But, one of the things with any of this type of documentation, so, whether it's a letter that comes back from the physician or your notes on this type of conversation with an employee, as Mary Ellen said, it's not true medical diagnosis or medical documents, but it relates to, the medical state of an employee. Always want to keep that in a separate file, right? So that should not be in the same file, or frankly, shouldn't even be in the same filing cabinet as, an employee's application or W-4 or I-9, things like that. Anything related to these types of conversation, you really want to have in a separate folder for that employee, and ideally a separate filing cabinet.
Absolutely, Matt. That's a great point, and I'm glad you brought it up.
Yeah.
It has to be kept separately, limited access.
Exactly. Yep. I mean, I've heard so far as to go to separate filing cabinet with a different key than, what I'll call standard employee files.
Right. Then there's no issue. Yeah.
And that's, again, that's something that we see quite often. And, when we're doing our employee audits and those sort of things, it's just, nobody's fault, but it's sometimes these things just get filed away with all the other papers. Mm-hmm. So if we move on from documentation to the reasonable accommodation, right? So when we talk about accommodations, again, it's important to keep in mind that it has to be reasonable in nature, like you were just starting to talk about, Mary Ellen. So as we wind down the discussion here and look at a couple questions that came through, talk to us about what reasonable means and why the ABA makes that distinction.
Sure. So the employer does not have to, I touched on this a little bit already, but the employer does not have to change the job description or allow the employee to perform less than all of the essential duties. Again, marginalized duties can be redistributed, but the point of a reasonable accommodation is to allow the employee to perform their job. So if the accommodation would be an undue hardship on the employer, then the employer does not have to provide the reasonable accommodation. For example, a leave of absence can be a reasonable accommodation. I think a lot of employers make the mistake of thinking that because they can't come in for a limited period of time, the employee can't do their job, and therefore this is not a reasonable accommodation, but that's not the case. A leave of absence, a brief leave of absence, can be reasonable. An unlimited, indefinite leave of absence is not considered a reasonable accommodation. So that's the difference. Inconvenience is not the same as undue hardship. I've talked to a lot of employers who they lament over that this is going to be inconvenient. This is going to, cause a little bit of strife within the office. It may even affect morale. That's not the same as an undue hardship. An undue hardship is a pretty high burden to reach, and mere inconvenience is not an undue hardship. A reasonable accommodation is not reasonable if the employee poses a direct threat to the health and safety of the employee, him or herself, or to others, which a reasonable accommodation cannot negate. For example, an employee who perhaps operates heavy machinery and has a condition where they become dizzy and may faint. And it's unpredictable. So in that case, that person could cause a direct threat either to themselves or to another employee, and a reasonable accommodation would not be able to negate that. So as long as it's something that the employer can provide and the employee can do the essential functions of their position without being a direct threat or, being gone for an indefinite period of time, usually it's going to be considered reasonable.
Got it. And then, lastly, before we wrap up and take a look at some of the questions that came in, and I don't ask this to scare anyone on the call, but more to stress the importance of engaging in this type of conversation and this process. What recourse do employees have if they feel that their rights under the ADA have been violated?
So if they feel their rights have been violated, employees should always follow the employee handbook first in terms of complaints. And assuming the employee handbook says, you should contact this HR manager or your supervisor, whatever the case may be, employees really should use all available internal remedies first. And if for some reason an employer is just unresponsive, then the EEOC is where the employee should go. with their complaints.
Got it. Yep. And, especially with a lot of what I think we're going to start to see and probably have already seen related to COVID-19 and, coming back to the office, being recalled, wearing masks. I mean, again, it's employees typically know, or they quickly find out where they can go to raise a claim and kind of, strike some fear into the employer if they feel they need to.
Right.
So again, I think it stresses the importance of doing this the correct way and, and documenting as you go. And not every case is going to be as detailed or as involved as some of the ones that we've talked about, but just making sure that you're engaging in the good faith conversations, because, more likely than not, we're going to see an uptick in cases here with I would imagine the EEOC related to some of these COVID-19 requirements.
Yes, I have no doubt. I agree.
Yeah. Perfect. So then kind of closing on the learning objectives here and what we just talked about. So, now we know what the interactive process is, why we need it, who's required to follow that process. Like we said, how do employees and employers know when they need to engage in that process? What should that process look like? What types of forms and documentation are important to have, and kind of where to keep those forms and information once it comes back. And then, whether or not there's circumstances where an accommodation can be denied. As you said, it's a very high and hard bar to reach, but they're very well, may be. So we did have a couple questions come in as we look at our last 9 or so minutes here. So if we turn to those next, and I think a lot of these will help to drive home some of the points we made. The first question that came in is, can we now request doctor's notes for the expanded FMLA under the FFCRA and accommodation requests? An employee told this individual yesterday that they've had bronchitis a lot, and they don't think they can work with students because that person is prone to getting respiratory illness. So how would you handle that?
Well, just first of all, the extended FMLA is really just for childcare. That's for if somebody can't come into the office because they have childcare issues, because daycare centers are closed, the nanny won't come because of, a high risk situation, or if you're contracting COVID. So I just want to make that distinction. But if somebody's coming in and says, okay, I have bronchitis a lot as a kid, I don't think I can work with students, I'm prone to getting respiratory illnesses, then I do err on the side of getting medical documentation from the employee's treating physician. So I would have that employee take the questionnaire that the employer develops, best to do that with the assistance of legal counsel, to the treating physician and have them fill it out. So if the treating physician is saying, yes, this is really putting this person at high risk, they have an underlying medical condition because of the repeated bronchitis, they have an impairment, so they aren't able to do that, well, then the interactive process there is triggered, and you have to have that back and forth discussion. If the treating physician says no, they may need to wash their hands more often, or make sure they keep the 6-foot social distance, then that's a different situation. So I would rely on the medical provider to see what the employee can or cannot do.
Okay. And then the next question we have kind of speaks to that, that reasonableness of an accommodation, and, how you can work with an employee to find something that's suitable. So the question is, how do you handle an employee who submits a doctor's letter saying that they shouldn't return to their job at the front desk of a school due to their high risk status? Obviously having to be there in person, I figure front desk type of role, that's not able to be done from home, right?
No, certainly not. Well, so I guess they already have a doctor's note, so they already have a medical provider saying that this person cannot return to a job at the front desk. So they can't work from home. I would engage in the interactive process. Is there a way for the employee to do any part of their position, or a way to do their position so that they are not high risk? So that they're not exposing themselves due to their high risk status. If not, I would say here an unpaid leave of absence may be the way to go. I wouldn't suggest a termination at this point. I think it would be premature, but you certainly would not have to pay this employee just to be at home if there's no work that they can accomplish from home. So I would say an unpaid leave of absence for 6 weeks, 8 weeks, and then revisit where you are and get an update from the medical provider to see if they're able to come back at that point, and if still no, maybe another brief leave of absence. It certainly doesn't have to go on indefinitely, but I think it would be premature just to let the person go.
Yeah, that's a really good point. I mean, especially with the environment that we're in now, right? The hope of all of us is that at some point this is going to, subside and, to a large degree. And
right. I mean, if the employee, if a vaccine comes out, the employee is able to get the vaccine, and the doctor says you now have the vaccine, you're okay to go back to work. Well, then great. Then it was just a limited period of time. But it would, paying 2 people for this, the employer wouldn't have to pay the receptionist just to sit at home. It can be an unpaid leave of absence.
Got it. Yep. And then the next question here, and I do have 2 more that came in during the conversation that, for those of us who want to hang on, we can answer those 2 for you. But the next question is, does this also apply to individuals who are just uncomfortable returning to school, right? So they don't have a true disability, but they're in an age range where it's a high risk for them. So does the interactive process and what we've just gone through apply in that scenario?
It does not. It does not. So somebody that just feels uncomfortable, that doesn't fall under the Americans with Disabilities Act. There's no need to engage in the interactive process. And by the same token, an employer shouldn't tell an older person not to come in simply because they're an older person if they have no underlying medical condition, because then you could get into age discrimination issues there. So someone who says they just feel uncomfortable, no, the employer does not have to accommodate that under the Americans with Disabilities Act.
Great. And I'll ask Colton, if you don't mind, to transition to the next slide, which is going to be our closing slide, but just so we have our contact information up there on the screen for an extra couple minutes here as we answer these last 2 questions that came in today. Can you speak a little bit, Mary Ellen, about, COVID-19 as it relates to expectant or nursing mothers who are concerned with returning to work because COVID is a potential risk factor for them?
Well, pregnancy itself is not a disability, but some of the medical conditions that go along with pregnancy can be a disability under the Americans with Disabilities Act. So in that case, I would engage with the expectant mother's healthcare provider to see if she is able to come back and in what capacity and what she's able to do and what she's not able to do. Yes, I mean, if someone is pregnant and that puts them at a high risk, I think the ADA there is triggered and the interactive process needs to be engaged. Does that answer the question?
It answers the question as I was given it.
Okay.
I'm hoping it answers the question for the person who asked it of us. And certainly if it doesn't, like I said, there's our contact information. If you do have additional follow-up on that, feel free, of course, to reach out to either myself or Mary Ellen, and we'll go into a little bit more detail with you.
I mean, with the ADA, with the ADA in particular, Matt, I mean, I always advise, getting legal counsel for those types of issues. They are tricky. They are individualized. I find that my clients trip over those issues more so than a lot of others. So I would stress the importance of having legal counsel involved.
Yep. No, and I agree with you. And, like I said before, the EEO claims, whether or not they're valid and they're warranted, and depending on, whether or not the employer comes out ahead of the game at the end of it, it's something that you want to make sure you're doing this the right way, because even if you do end up, winning, if you want to put it that way, the claim at the end of everything, EEO claims take, exorbitant amounts of time and effort and energy that, people right now just don't have. And they can be very, very detailed and tricky to navigate. So like you said, spending a few extra minutes or hours up front with an attorney kind of helping to navigate the initial conversations are much better than spending the days and weeks on the back end.
I agree. And since this is all very new and it's unknown how things are going to be viewed by the EEOC, I would suggest erring on the side of being employee friendly here. This
Yep.
is uncharted territory for everybody, and I think it makes sense to make thoughtful decisions, that knowing that a
Yep.
lot of this is temporary.
Got it. And then the last question here, Mary Ellen, before we wrap up, is might be a little bit of a heavy one, but can you touch on mental illness and reasonable accommodations, especially since there's going to be a lot of fears surrounding COVID-19? And you and I were actually on the lead up to this call, kind of talking about just the sheer anxiety that this is causing, right? The fact that you may go to the grocery store, to pick up necessities, and then for the next 2 or 3 or 4 days afterwards, you're just super anxious about, did you catch COVID-19?
Right.
So how does mental illness play into all this?
Well, it's so nebulous that I think that's one of the cases where it's very important to rely on the employee's medical provider, more so there than I think in any other, when you're talking about a physical disability, because that's a little bit more cut and dry. So we're all anxious. I think everyone is at this point, but some people, that anxiety is a disability. It's beyond the average anxiety that we're all feeling. So I think in that case, if someone comes to their employer and says, I'm just feeling very anxious about being here, it makes me really nervous just to be here, then again, I would engage the medical provider and have them come in with a doctor's note. And if the doctor's note says, yes, they're at such a state that they are not able to perform their job at this point in the office, if it's something that they can do from home, wonderful, problem solved. If it's not, then you have to dig a little deeper in the interactive process. But with mental health issues, I think it's very important to send a questionnaire to the healthcare provider and see what the healthcare provider's opinion is, because employers shouldn't be making medical decisions. Employers aren't equipped to make medical decisions. So that's where the healthcare provider comes in.
Got it. And I know, I said that was going to be our last question, but I have one more, because I know it's going to be a softball for you. Question is, doesn't the age of 65 and over put you at high risk for COVID and therefore trigger the ADA?
Just the age itself does not trigger the ADA. It makes you more susceptible, I agree. Medical professionals have said that, but it doesn't mean that the person has an underlying medical condition that triggers the ADA. Just being older is not a disability. Therefore, the ADA is not triggered just due to the person's age.
Perfect. Very good. Appreciate you taking that last one.
Yeah.
So with that, Mary Ellen, listen, I can't thank you enough for your time on both of our webinars here, and hopefully we'll get the opportunity to work together on some more coming up here.
Absolutely.
But, also want to thank our audience for joining us and listening in. Like we said, please reach out with any questions that either we didn't answer today that you might have, or that you weren't comfortable asking in the broader audience here. But other than that, as always, thanks for your time, and stay well, everyone.
Great. Thanks, Matt.